My name is Christy Myatt, and I'm part of the Farm Credit team here at Nexsen Pruet. This video will cover criminal referrals under the Farm Credit Act. Unfortunately, criminal activity is becoming more rampant in the lending arena. It may involve employees, borrowers, or third parties. It can also involve wires and hacking, which seems to be more prevalent lately. We have been involved in a number of criminal or fraud investigations recently. Some of these investigations have cost associations much more than their actual losses because no one spoke up when they saw red flags or suspicious criminal activity. Following are some examples of criminal activity: diversion of loan proceeds, check fraud, filing of false financial statements, false identification, fictitious collateral, false notary acknowledgement, forgery, embezzlement, conversion of collateral, misuse of position or self-dealing, money laundering, and identity theft. The Farm Credit Act provides the applicable reporting guidelines and thresholds for filing a criminal referral. Under the Act, an association is required to report any known or suspected criminal activity when 1. The suspect is an association, employee, officer, director, agent, or other person participating in the association's affairs, regardless of the amount of the actual or potential loss. Second, when the suspect is a borrower or other third party and the actual or potential loss is $5,000 or more, which results from false financial statements or fraudulent means. Third, there is no identified suspect or possible suspect and the actual or potential loss is greater than $25,000, which results from false statements or fraudulent means. And fourth, when the known or suspected criminal activity involves a financial transaction in which the institution was used as a conduit for such criminal activity, such as money laundering or structuring schemes. As an employee, officer, or director of an association, your duty is to tell someone at the association about the activity, regardless of whether the applicable dollar threshold is met. The association will then investigate and determine whether a criminal referral should be filed. Each association is required to have a criminal referral policy. Read it and know it. Most policies recommend that the known or suspected criminal activity be reported to the SOCO officer or whistleblower hotline. Remember, reporting is confidential and, if made through the whistleblower hotline, the reporting is anonymous. Once an association has been made aware of the known or suspected criminal activity, its duty is to investigate. If there appears to be a reasonable basis to conclude that a known or suspected criminal activity has occurred under federal law involving the assets, operations, or affairs of the association, then the association is required to submit an FCA criminal referral form to FCA and to law enforcement within 30 calendar days of such determination. This action is mandatory, as failure to file a criminal referral could subject the association to supervisory or enforcement action by the FCA. If immediate action is warranted, the association should also contact federal or state law enforcement as applicable. Criminal referrals are confidential and should not be disclosed to the suspect, nor should they be used as a debt collection tool. Remember that it is the responsibility of all employees, officers, directors, agents, or other persons to exercise due diligence and to promptly report all known or suspected criminal activity related to an association, including any known or suspected criminal violation of federal law involving the operations, assets, and affairs of the association, or any violations associated with or committed via e-commerce. If you have any questions or need more information about the criminal referral process, please feel free to call me or any of the other members of the Farm Credit team here at Nexsen Pruet. Thank you.